Good morning. Let me ask everyone if they would just to turn their cell phones to the off or vibrate position, if y'all don't mind. We had under consideration Senate Bill 151 yesterday. We've had a substitute drawn up in the interim that I'll do my best to stumble through and welcome any comments, questions, or comments from the author about it. And it's a reflection of the testimony that we heard, as well as suggestions from members of the committee as well, frankly. The first substantive change, well, actually one was just really more cosmetic. We had the expression, I'm looking at the new sub, not the old bill as it came over. We had verbiage, the undue burden to the witness, that was in, I think, at least 2 locations that just was misplaced. We went ahead and struck that. The first really substantive change was had to do with members of the immediate family who may testify. And we went ahead and, I believe, erred on the side of inclusiveness as opposed to exclusion in terms of including those folks who would go ahead and testify, and that would, the members' immediate family is listed out. I think it's pretty straightforward on the bottom of page 1. Let me ask Ms. Travis a question just to make sure that we're on the same page here. With regard to, make sure I've got a clear understanding myself, the members of the immediate family, as we've defined them and listed them for purposes of this substitute, these are the members of the family who cannot be excluded, correct? Okay, I just want to make sure that was clear. And again, we're erring on the side of inclusion as opposed to exclusion in a situation, in a serious situation such as this. The other changes that we made were on the suggestion of the agreement of the defense bar and the prosecution, and this goes in paragraph on page 2, beginning on line 38, where we took out the teleconference mechanism, for lack of a better term. Members, specifically Mr. Knox and Ms. Byrd, and I believe Mr. Franklin as well, had a suggestion on the audio and video statement that you see on line 42, that we amend that slightly to a pre-recorded audio or video statement, and then on into the rest of the paragraph as it stood yesterday in the substitute. One question I would have for Ms. Travis is that my sense is that on page 3, on line 67, we would do well to go ahead and mirror that language, the written, oral, audio taped, or videotaped testimony. We probably want to match that language that we had on the previous page, the pre-recorded. Yeah. Okay, and then we can go ahead and mirror the rest of it on page 2, and we'll. Well, if we're mirroring the language on the previous page, probably statement, correct? Is that a? Oh, you're right. I mean, right. My sense is that it should match up as best as possible with the previous language on page 2 in section 4. Would that be your presumption as well? Not necessarily.
Well, Mr. Chairman, if I could.
Sure.
Videotape. I don't know. Maybe we need to ask.
Could you pull the microphone forward? Thank you.
Maybe we need to ask the people from Pardons. Do they also get videotape testimony and use that in the parole decision? I don't know. I mean, I've never gone and done a parole hearing, so
I don't know either.
I mean, because you can do video depositions, and this is a parole decision.
Let me ask. I hear.
We don't normally, but we can get something. We would accept it if it came in.
So my point would be it would be testimony. That is actually probably testimony as opposed to a statement.
So keep the language as is. I see nods in the back from paroles.
Yeah, I mean, it's just if it's just to do style, this is what they're.
Okay. Ms. Travis, do you have strong feelings about that?
Well, no, I don't. I guess, though, for technology purposes, you may want, it would be pre-recorded, so adding that word and taking out the word tape
Okay.
makes sense.
In order to mirror the language in the previous page.
Yeah.
So, to some degree, but we'll leave the word testimony. I'll massage the sentence up maybe.
Very well. I see 1, 2, 3. Ms. Abrams. Okay. Okay. Thank you. It's fairly straightforward. Any questions or statements either of the author or of me or of anyone else by members of the committee? Mr. Levitas.
I just wanted to commend the author on this fine piece of legislation, let him know how forward I'm looking to be in before his committee this afternoon, and the appropriate time I'd like to be recognized for a motion.
That time would be now.
Mr. Chairman, I'd like to move due pass LC 293853S.
We will. That would be fine, Mr. Martin.
And I understand what we're trying to do with the immediate family. I'm a little concerned when we go past stepbrothers and stepsisters. And I remind the committee of the decision of the Georgia Supreme Court in Livingston versus State, where when they upheld the admissibility of victim impact statements, they specifically said that the trial court still had as a precautionary measure the ability to limit the evidence to some extent. It said actually even to exclude it altogether. And that was part of their reason for upholding its constitutionality. And Payne versus Tennessee, the Supreme Court case which allowed it, said that the court will always have the ability to control this so it doesn't go too far. What concerns me is since we're giving an absolute right to all these people to testify, doesn't mean that the judge in his discretion could allow a stepbrother, or a mother-in-law or brother-in-law or so forth to testify. That you are, you're starting to limit the discretion of the court in such a situation that you're starting to press the envelope a little bit with regards to the Livingston analysis. My only suggestion is that we stop. I can understand all the way up to stepsister. It seems to me we're going a little far when you go over absolute right for a mother-in-law, father-in-law, sister-in-law, brother-in-law, and then the spouses of each one of those individuals. We may be going a little too far, and we may be pushing the envelope. I will say this. I do believe, since Payne talks about the due process clause trumping this, in an appropriate case, I mean, if we come up with like 15 to 20 family members that might fit this, and you could easily, a court at some point could say, listen, this is going too far, and maybe from a due process analysis could say, I think the due process clause gives me the discretion to limit it. That's what Payne versus Tennessee says. But I'm a little concerned when we get this many people past stepsister, stepbrother, up to that point. That would be my understanding of immediate family, quite frankly. Just
let me make a point about that. I hear you loud and clear, and I think you make some valid points. That being said, I think the immediate family of today, and more important, the immediate family of a generation from now, is not what you grew up with, and it's not what most of us grew up with, and that the conventional family is not the and I'm not saying that you're saying this, Mr. Martin. I don't think I can define the conventional nuclear family, if there is such a thing anymore. There are extended families. You have grandparents raising people, you raising kids. You've got sister-in-laws. You've got extended family. Depending on personal situations, which I can guarantee you are getting more and more complicated on a domestic basis every day. That being said, I hear your analysis and I take it seriously. If we are going to go ahead and push, query as to whether or not we're actually pushing, but if we are pushing, my sense of it is that we would want to go ahead and push erring on the side of those particular individuals in the family. Mr. McDade is under no duty to respond to Mr. Martin, but I wanted to give him equal time if he wants it. Boy, there's a first. There are comments from members of the committee. Mr. Knox, and then around.
Mr. Martin, my own.
Yes, sir.
Oh. In light of your objection, you still want to stand with that objection because this says that any other witness having personal knowledge of the impact on the family or even the community, any other witness is a lot more broad than the immediate family or the members of the family.
Chairman Knox, but those are in the discretion of the court. What we're saying here is these people have an absolute right to testify. If your best friend is really the closest person to you, knows more about you, that could be victim impact evidence. But the court, you wouldn't have an absolute right. What we're saying here is that these family members, including spouses of brother-in-laws, I can't figure who that might be actually, but absolutely have a right to testify, and otherwise the court has discretion.
Ms. Benfield.
Ms.
Oh, I'm sorry, Ms. Abrams.
It's okay. Thank you.
You got to
Mr.
have that down by now, but no.
That's okay. As long as you don't call me Jacobs, I'm good.
Duly noted.
You started. We almost forgot.
I only remembered because of never mind. I'll leave it alone. I would push this a little bit further because the last line, even if we accept the notion of extended family, although immediate family, when otherwise defined in the code, according to just brief research yesterday, is not nearly as expansive. But what we've said is not only immediate family and step family, in-laws, and then we've added the spouses of any of the people who are on that preceding line. So you could theoretically have every spouse of every child, every parent, every step-parent, every grandparent, every grandchild, every sibling, every stepbrother, every stepsister, every mother-in-law, every father-in-law, every sister-in-law. All of those people would also additionally be. I'm the second of 6 children, many of whom are getting married in the next 6 months. That would be a remarkable number of non-discretionary witnesses, and I do think that we should take very careful notice that we've expanded beyond even the most, I think, germane notion of what should be granted as an immediate circumstance. I do think that is a bit expansive, and we might want to consider what that number looks like.
The lady's point is well taken. Again, we have erred on the side of inclusion as opposed to exclusion. My sense of it is if the lady has an amendment that seeks to strike a balance while still erring on the side of inclusion or exclusion, certainly, as always, that amendment will be entertained and voted on through an open process.
Thank you.
Mr. Wiles.
Thank you, Mr. Chairman. If I could respond, we're also, I would ask the committee to look at line 20. While it limits the number, that says immediate family, it says in any event shall be permitted in only such a manner and to such a degree as to not inflame or unduly prejudice the jury. So what we give in the first 2 lines or 3 lines of that subparagraph, we take back with the discretion back to the trial judge. And I think that's why this clause and this inclusion isn't constitutionally deficient. I think we still allow the judge the discretion.
It still strikes a balance.
Still strikes a balance. I think it's a fair balance. And
that's the chair's sense as well, which she doesn't seek to impose on anyone. Again, erring on the side of inclusion rather than exclusion. To the Chairman Wiles' point about the judge having discretion regarding the manner and degree. Mr. Collins.
I have a question on that and to the author. I understand what you're saying, but if you read and if I'm reading this incorrectly, starting at line 18, the admissibility of the evidence described in paragraph 1, which we put shall allow family members of this subsection, the number of witnesses other than immediate family member who may testify shall be in the sole discretion. We're taking family members out of that other. And so basically what you said, he does not have the discretion except maybe, as Mr. Martin said. And I'm just curious here to the question to be a due process.
Well, if your question is to me, the answer is the fear is, as it's currently the current law, the judge can limit to 1 witness.
Exactly.
And if the witnesses repeatedly testified over all the hearings that it's important for the family members to be allowed, and we're given discretion to limit it so it isn't constantly deficient. But we're also saying, in a case like this, family members need to have the opportunity to testify. And it was, in fact, my constituent, Wayne Brown, who lost his daughter in my district. And so he was very, very upset about the limitation. And that's what you've heard from. And I mean, I think it's a fair balance. I do think the judge's discretion is there. they might not be able to limit, but he can say you can say 2 minutes or 1 minute. Before he or she could say no.
So just to clarify, and I agree, I'm in support of the bill. Because I'm just making sure that you're saying that he can limit. You're talking about the discretion as far as how long they can speak, what they can speak. But the bill, you would agree though that the bill does not allow him not to allow these listed members to speak.
And that's correct.
That's correct, and that's the balance that I think the author and I share, and we'll just see how the process plays out. There is a motion for Mr. Levitas. Yes, sir.
I'm actually concerned on the other end because the way I actually read lines 18 and 19, the way I read it, while the judge could not control the number of witnesses, he could choose not to admit any of them because it says the admissibility of evidence shall be in the sole discretion of the judge. The number of witnesses is not limited, but I think he could still decide possibly to exclude all of it. He just couldn't exclude numbers. So I just want to I'm trying to help.
And I understand, and I think that is existing law, and I don't know that we heard a lot of concerns from the witnesses that they are doing it, but I think constitutionally, without taking Mr. Martin's role, I think you have to give that discretion based on Supreme Court decisions to the judge. Mm-hmm.
Mr. Travis, I see. It's my sense that the way that Chairman Wiles is describing the substitute does provide, as per Mr. Collins' comment, that who shall, under the substitute as proposed right now, that those individuals shall be allowed to testify, but the judge still maintains discretion as to how that occurs. Is that your understanding of the language? That's my understanding of it, but I wanted to make sure we're on the same page.
I'm not sure because to me on line 19 when you say other than immediate family, to me that takes it out of the sentence.
Right.
So I'm not seeing the way I guess I'm
Oh, I see what
reading
you're
it is if your immediate family is coming in.
If it's other than immediate family, it's the sole discretion of the judge. And if it's not, then it's immediate family, and it's not. That goes back to Ms. Abrams' point about is that more expansive than it needs to be or not, and that's a question we'll solve, I think, in a few minutes. Okay. That's how I read it as well. Okay. There is a motion by Mr. Levitas. Is there a second? There is a second by Mr. Bearden. Are there any amendments? Ms. Abrams.
Thank you, Mr. Chairman. I have been incredibly supportive of this bill, both through the subcommittee process, the amendment process, and the hearing process, and I thank Chairman Wiles for taking this cause on and bringing it before this body. I've been very persuaded by the balanced approach that both Mr. McDade and Mr. Martin have taken to protect the rights of victims in this instance, and I think that is the intent of the bill, and it should be persuasive to all of us. My concern, however, is that when the practical effect of not putting limitations in here is that given even our limited reaction through 2 sets of hearings, and I sat through the victim testimony both times out of an abundance of respect to the men and women who came to testify, the limited emotional impact that it had, or the emotional impact it had on us sitting in this room, I think it is, as a practical matter, going to be very difficult for a judge who is compelled to admit testimony from all of these people to also practically limit the heightened emotional nature of that testimony once they're there. And so I think it is incumbent upon this body as a policy matter to take into consideration we are establishing a standard that would allow an enormous number of people unfettered access. And I do agree with the reading of the law to say that the judge could be permitted to limit it in such manner and to such a degree, but I think that the practical effect is something we have to take into consideration. This is an expansive number that is not consistent with any other definition of immediate family that we currently have in our code, and I would therefore ask that this body strike, beginning on line 24, insert a period after the word brother-in-law, and strike "and the spouses of any such individuals." I am compelled by the notion that the in-laws certainly have valid testimony and should be allowed. But I think adding that additional line is overly expansive and is not consistent with any existing standard.
Ladies' amendment, line 24, to strike, put a period after the words brother-in-law and strike the words and the spouses of any such individuals. Is there any further discussion on the amendment? Mr. Levitas.
I will tell you that I have, fortunately not been the victim, but I do have personal experience with this. Somebody that works for my company is the brother-in-law of a murder victim, and it goes back far enough that Nancy Grace was the prosecutor in that case, and it still has an incredible impact on that family and on that individual. And while there's not a blood relationship, you may be talking about somebody who's been a member of the family for 20 years, and I would hasten to strike spouses because that is relevant. It does have an impact on the spouses, even if it's not a blood relationship.
Yeah.
Thank you. Any further comments? Any further discussion from members of the committee? Mr. Hatfield.
I'd just like to know. Thank you. I'd just
Yes,
like
sir.
to know what Senator Wiles' opinion is on that amendment.
I would prefer the language that's been negotiated, compromised, and worked on remain in the bill.
Mr. Knox.
At the appropriate time, I'd like to be recognized for a second on the motion by Representative Abrams.
It just happened. Thank you. Any further discussion on the proposed Abrams amendment? Ms. Abrams.
The last point I would make is to Mr. Levitas' point. I believe that the capture of the language, for example, the brother-in-law, I think that the judge retains the discretion to admit any other testimony. What we're creating is an automatic right, which reduces judicial discretion. And I think that it is incredibly important that we recognize that the expansive nature has to be balanced against judicial discretion. And the more people we add on this side, the less discretion we grant the judge to make sure that there is no opportunity for overturning at a later time. And so I do think we have to think about the totality of this action, and would ask your support of this amendment.
Thank you, Ms. Abrams. Points well made on both sides of the issue. On the question of the Abrams amendment, line 24, page 1, period, at brother-in-law, striking the words and the spouses of any such individuals. All in favor of the amendment, please signify by raising your hand. Opposed? And the amendment is not adopted. Are there any further amendments? There is a motion, there is a second of adoption of Senate Bill 151 by substitute. Ms. Travis, let me just make sure that we are all on the same page, and the committee understands that substitute will encompass the amendment of the language as relates to the parole board in line 3 that we discussed earlier. Is that correct?
Line 67?
Yes. Or are we leaving as is?
No, we're going to make some changes.
We're going to, just to make it consistent with the language on the previous page, correct? It's stylistic. With that in mind, there is a motion, there is a second of do pass substitute by substitute as amended, Senate Bill 151, LC 293853S. Any further discussion? All in favor, please signify by raising your hand. Opposed? And the motion is adopted. Thank you, Chairman Wiles.
Can I say one thing?
Sure.
The hearings in this committee made it worthwhile for me to be a senator. I was amazed by it. And if you didn't sit through everything, the amount of work your committee and subcommittee did, I really appreciate. This is important stuff, and it was very tough. And I asked the victims if they wanted to do it over and over again, and they all said yes. I felt, and I really appreciate y'all sitting through it and making this bill a better bill. I truly do.
Thank you for bringing it. We're a pretty good bipartisan team in here generally, so. Thank you.
Well, I used to sit right where that chair is tilted up. Well, it was mine before he got it.
The chairman of rules is restless. Chairman Balfour, welcome, good morning, and thank you for your patience.
Mr. Chairman.
Thank you, Mr. Chairman. Senate Bill 246, members of the committee, Senate Bill 246.
There was a committee substitute with some amendments that was brought through the subcommittee. I think there were even amendments made to that, which I don't have a problem with. Actually, there were good amendments to be made. And basically, we have a situation that came up in my county where a young lady was being stalked by a 15-year-old boy to the point that he broke into her house with a knife. He went before juvenile court and spent 90 days in detention and, probably psychiatric review or whatever else we do. And when he was let out of jail, within 8 hours, he was back at the house, this time with a gun. And the father's point to me was not that the boy didn't have rights, and as a juvenile, kids make mistakes, and we need to make sure that, we don't ruin their entire lives, which he agreed with that completely, but that he as a father should have the right to know when this person who's trying to take his daughter out is let out of prison. This girl now is, I don't know, 15 or 16 or 17, and in essence, she's in jail. There's no prison walls, there's no guards guarding her, but she has to look over her shoulder every moment of every day, wondering where this guy is or when he may be coming back. And basically this would require a notice 24 hours before this type person is let out of prison or let out of juvenile detention center. I worked out this language with Danny Porter, the district attorney in Gwinnett County. I've had a number of conversations with the Department of Juvenile Justice, and they made some corrections to our verbiage to make it more in line with other things that are in the law, and there's no problem with that as well. So if, I'd be open for any questions you might have.
Thank you, Mr. Collins.
I just want to be recognized for a motion.
All right. Any question? Ms. Benfield.
Thank you. Thank you, Senator, for bringing this bill. I just have a quick question because I was surprised that this wasn't already the law. And I was told there was an attorney general opinion on this issue that stated notice should not be provided. Can you elaborate on that? Because I wasn't able to find the AG opinion looking on the web.
Well, I'm a little at a disadvantage not being an attorney, but that's from what I found out later, it's a 1996 opinion I may have the year wrong, but I think it's 1996 opinion. But I will tell you that although that may have been the opinion of the Attorney General at the time, for the last 12 years, the state of Georgia has been notifying people according to how some of the law is already set up.
With the difference being that the notification is in place. If I'm trying to understand it as well. The notification is in place if the offender is a adult, but it's not consistent when the offender is a juvenile. Correct?
You may.
That's the hole we're trying to plug.
Ask my lawyer that question.
I understand.
Excuse me, Amy Howell from the Department of Juvenile Justice. We were not aware of this opinion, so we have been providing notice for certain offenses, including designated felony. So there has been some notice provided to victims.
When the offender is a juvenile. Okay, but that is not in statute right now, correct?
There are the designated felony statutes do require notice prior to release, so those provisions do include notice, and then the other provisions that we were complying with were in relationship to the victim's bill of rights.
Okay. So that I guess then the question that I'm hearing from Ms. Benfield that I share is that what is the hole that we're plugging then?
The hole that this bill plugs is really pre-sentencing. So this is being detained prior to adjudication and post-adjudication, perhaps prior to disposition, and notice would be provided if any release occurred prior to that.
Okay.
The notice we're providing currently is post-disposition.
Mr. Sessler.
Hey, Mr. Chairman. I'm on page 2. I had a question for the author on line 28. And not having had the benefit of subcommittee, I do want to ask a question. Starting on line 27, the juvenile court intake officer shall, words, whenever practicable, provide notice to the victim of such pending release. I mean, there's certainly no remedies in this if by chance it didn't happen and someone made a good faith attempt but didn't make notification. And I don't think that's our intent. Why do we need the words "whenever practicable," making it seem more optional? It seems like there ought to be a sort of directive to do that, to be more prescriptive.
And that's a good question. Basically, if you go through the whole code section on these type things, you have that verbiage in there, whenever practicable, because let's go back to this example, and I'm the father. If I don't have a phone number, if I don't have an email address, if I don't have how am I going to give notice? So they almost put that verbiage in there for, obviously it's going to be practicable if I gave him my cell phone number and so forth. But that verbiage is throughout the law.
So we're directing a good faith effort, but we don't require someone to go to the ends of the earth to find the person to make the notification if that's not
that I believe that's correct. I think that's the.
Mr. Knox.
Maybe I guess this is for the leg council. We're putting in the reference to code section 1511 on line 16 and 17, the reference to 1710 6.1 and 1511 63, one being a designated felony and one being a serious or violent felony. And is that consistent with the language that we're using on 27, where we're talking about a violent delinquent act?
A violent delinquent act includes lines 16 and 17.
Those are, but this is not in the code currently, is it? 16 and 17, or is it? Are you just, because this is new, we're adding it? Are we just adding it for this code section, just as a reference?
As far as I know, there's not an animal called violent delinquent act in the code.
Yeah, that's my point.
For this code section.
Okay.
And so a violent delinquent act is going to include a designated felony, a serious violent felony, stalking.
Okay. So then juvenile justice is going to have a few other things to report on, keep track of, correct? I mean, you're going to start notifying more people than you did before on different cases, right? Okay. Thank you, Mr. Chairman.
Yes, sir. Ms. Benfield.
Yes, thank you. Not to belabor the point, and I do support this bill, I do have just some concern about what's in this Attorney General opinion. So I don't know who to direct the request to, maybe Ms. Howell, although I know you have plenty of work to do already, but I would like to see the Attorney General opinion, even if we pass it out today, just to make sure that we're not overlooking something, because I'm curious why the Attorney General ruled back in 1996 that notification should not be given.
Do you want to speak to that, or do you want juvenile justice to?
I have the opinion with me. So
I'd like to see it. Thank you.
Basically, what it says is that within the definitions in the Victims Crime Act, that the definition of crime does not include a delinquent act.
And so what we're doing is
we're changing it.
We're fixing that. Okay.
Thank you.
Mr. Setzler.
Mr. Chairman, one thing that I don't know if it was an oversight of the author, it came to mind a specific case in my district where a young man was adjudicated for a crime that, had it been committed by an adult, it was kind of on the line between battery and aggravated battery, but it really played out in a battery kind of framework, and he was let back out of the custody of the state and was back in the high school making very aggressive, threatening, not approaching assault, but making very aggressive, threatening gestures and things towards the victim within a week or two after this happened. Again, I know we don't like to make the law on the fly. Is there any reason that battery is not included as one of the potential misdemeanor offense-like offenses that could be included in this? Because if there was a battery-like offense, that wouldn't meet a felony threshold, as I understand, but still could kind of meet the spirit of what you're trying to accomplish.
Let me attempt to answer that. Is that my assumption is, subject to confirmation by the author and by juvenile justice, is that I think what they're trying to get to are the more serious acts. If the vice chair will permit me, I've just committed a battery right there. I don't know if I left a mark or anything, but I just did. So I think where they were going with this is on the more serious
I just in
well, he was otherwise occupied with technology. Is my statement? Is my story? And I'm
call that a
sticking to
love
it.
battery in the house.
But you see the point that I'm attempting to make. But I'll look to juvenile justice to see, is that the intent on we're going for the more serious offenses, obviously.
I mean, Mr. Chairman, I just this is a kid who had friends standing around as he smashed his face into a brick wall, and there was a lot of attitude and trash talk and all that. It just was a pretty egregious set of facts, but I don't know that it meets these necessarily.
I would obviously defer to prosecutors on it. My sense of it is that that's a much more serious charge than certainly a simple battery. But that the intent of the bill, if the author confirms or denies, is going the more serious acts.
Absolutely, that's what we're trying to go after is very serious offenses that you'd want to make sure that the family members would know that they could protect their daughter in this situation, and that's the reason for the 7 deadly sins and so forth.
Which is not to belittle any situation like that. Right. I want to make sure that's clear. Any further questions from members of the committee? Seeing none, Mr. Collins.
Motion to pass SB 246 LC 293858S.
There is a motion by Mr. Collins and a second by Mr. Bearden. Any further discussion? Are there any amendments? Seeing none, on the gentleman's motion of move due pass by substitute Senate Bill 246 LC 293858S, all in favor signify by raising your hand. Opposed? And the motion is adopted. Thank you, Mr. Chairman. Thank you. We'll call Senate Bill 172. Chairman Hamrick.
Thank you, Mr. Chairman. I would like to echo Senator Wiles' comments that it's always a pleasure to work with this committee. I'm not under oath, am I?
Not yet. Mr. Tarver, I understand that Senator Tarver's bill was...
That hasn't passed yet, though, has it?
Maybe just a matter of time. There you go. There you go. Only a matter of time.
I appreciate y'all had a bill yesterday that you improved for me, and I appreciate that. I was sorry I couldn't be here. We were trying to get our budget out, so thanks for that yesterday. And today I've got Senate Bill 172, which is legislation I've been working on with the Office of Child Advocate and the Criminal Justice Coordinating Council that would expand the victims who are qualified to receive compensation from the Crime Victims Emergency Fund. And it would expand it to children who have suffered emotional abuse and who have been sexually exploited. The purpose of the bill is to be able to pay for counseling for these children, and as it's currently written, because it only allows compensation for physical injuries, they are not able to do that. And so the purpose of the legislation is to basically allow children who have suffered emotional abuse and been sexually exploited to have their counseling paid for. And obviously, since the fund is asking for this, it will not be a significant cost. They are not worried about it having a negative impact on their ability to pay for victims' compensation.
Mr. Chairman, let me make sure I understand this. The Victims' Compensation Board has the ability to recommend compensation for crime victims. What you're proposing to do is simply add serious mental or emotional trauma as an additional pretext for which an award can be made. It doesn't guarantee that it's going to be made, but it allows that board to make a recommendation and to adopt a position of making an award for that type of injury, which it statutorily cannot do right now. Is that a correct statement?
That's correct.
Okay. Let's make sure I understood that. Questions from the committee? Mr. Collins.
I have a question, and I maybe just it just caught my eye. Page 6, starting at 187. K1, and maybe I'm just misunderstanding the purpose of this bill. What is this issue with Department of Transportation and a sign that runs through 213?
Well, that's the current.
It's just current language. Okay, I was just curious because you had to add you added date and name, so this is just all part. It's not.
Double underline is like demarcation of something singularly underlined in the code.
Okay, that's fine. As long as I was just running through it, just all of a sudden you're jumping from one thing to another. That's why I was just curious as where it came from. So if it's a part of law, my question is answered. Thank you.
Mr. Malone, would you introduce yourself to members?
I'm Rick Malone. I'm the director of the Prosecuting Attorney's Council, but I'm the chairman of the Victims Compensation Board at this point in time. This was added, that particular section was added several years ago to make uniform and make available to victims of traffic deaths in the highway signs rather than the ad hoc crosses that people put and things of that nature. And that's all it was done. And to be able to pay for it out of the victim's compensation,
Yeah, no problem, Bill. Not wanting to stop it. I just curious what.
Mr. Bearden. Ms. Banfield, did you have a question? Are there any further questions for the author? Is there anybody in the audience who would like to be heard on Senate Bill 172?
Chairman, y'all have my talking points from our office. I just want you to know, I think this is the most significant to me, all the legislation I've seen this year in terms of its potential impact to help victims. It's one of the best I've seen. I didn't come up with it. We certainly do support it.
Thank you, Judge Rawlings. Mr. Knox, did you have a question?
I have a motion at the appropriate time, Mr. Chairman.
I recognize Mr. Bearden for, unless you have a substitute motion. Okay. Mr. Bearden?
Make a motion that Senate Bill 172, LC number 293674, do pass.
There is a motion and there by Mr. Bearden, a second by Mr. Collins. Any amendments? Seeing none, any further discussion? Seeing none, on the gentleman's motion of do pass by substitute. Oh, no, you see, you're just changing the rules on me. Well, I know, but sometimes, we just like to do a substitute anyway, don't we? It's your world and I'm just living in it, Ms. Travis. Because every time I think we're not doing it by substitute, I'm told we're doing it by substitute. So I'm just trying to obey the authorities. There are no changes in the bill, so we are adopting Senate Bill 172, LC 293674. There is a motion. There is a second. There are no amendments proposed. There's no further discussion that I can see. All in favor of the gentleman's motion, please signify by raising your hand. Opposed? And the motion's adopted.
Thank you, Mr.
Thank
Chairman
you.
and members.
What did you do?
Mr. Hamrick,
We'd like for you to count.
who's handling that bill on the floor for you? Ms. Harden needs to know.
They got plenty of money.
That part.
They have a rolling. They have a rolling
Would you like to handle it, or would you delegate somebody to handle it?
I tell you what, your representative and I will go ahead and.
It might be better what Rich handled for the chairman handle.
My sense is that Representative Lunsford has a desire to carry that, and that would certainly be in able hands.
I would prefer that we get somebody that can actually get a bill through the House.
I'll be glad to handle
it. It'll be no. No, if he were, he'd have equal time beginning.
Yeah, that's
believe
fine,
me.
that's fine.
But it'll be a team effort.
Okay.
Thank you, Senator.
Hey, Bill Durden's going to tell him what you said.
The subcommittee this morning, the Knox subcommittee this morning passed out, I understand, Senate Bill 196 by Senator Jackson. Of course, my hope, and in terms of just getting, for time management purposes, we miraculously have a little extra time. By the same token, we didn't give notice to Senator Jackson about the possibility of considering Senate Bill 196 today. I think what we'll do, out of an abundance of caution, is we'll just hold that until tomorrow morning. Yes, sir.
I've talked to him about this
Yeah, he was here for the subcommittee meeting.
Subcommittee meeting this morning.
Okay, so Ms. Levitas, you're going to handle it right now?
I'll be happy to.
Okay. Then we'll go ahead, and since we're here and we have the substitute, we have Senate Bill 196 in our folder for management purposes. Let's go ahead and consider that.
If I suffer mental or emotional trauma because I was present during a crime, then I can be able to collect money.
And Ms. Levitas, you have the floor.
Why didn't I say anything?
Bring before you the substitutes to Senate Bill 196, LC 293860. Section 1 of the bill.
Let me ask you to hold on 1 second. Do members have the substitute in their folders? All right, just want to make sure. Thank you. Yeah. Thank you. I apologize. Please continue.
Section 1 of the bill creates a new 40-5-573 that deals with the suspension of driver's licenses for any person convicted of Oh, no, I'm not.
Section 1 of the bill is 40-5-20.
We're looking at 3860S, correct?
You're absolutely right.
Okay.
Section 1 of the bill merely corrects something that, according to learned prosecutors, we messed up last year, and so this is really just clean up language that the courts have said we need to clean up, and that's all it does. Section 2 of the bill creates 40-5-73, which has to do with vehicle and homicide license suspensions. I think it's actually serious injury by vehicle, if I'm not mistaken. And it just creates new suspension. Section 3 of the bill merely corrects. Is this Lunsford stuff? This is Lunsford stuff. Section 3. I'm sorry, we just got this substitute. A lot of this language added this morning. Section 3 of the bill merely strikes the language dealing with driving with suspended license that has that allows somebody to present a license, a valid proof of license, and not have a suspension of license go on the record. It just removes that ability. Section 4 of the bill deals with the serious injury by vehicle. Again, this was some language that has to do a lot with how the information is transmitted. Right now the offense is a $250 fine, but for a subsequent offense there's a 5-year period of time. For a 5-year period of time, there is a fine of anywhere from $500 to $1,000, and at 12 months makes it essentially a misdemeanor and makes the fee non-waivable. Section 5 of the bill had to do with some concerns addressed about serious injury by vehicle. This amends current code and just includes joggers and runners in the code that's already existing that just says if there's a sidewalk available, you have to use it. I do have amending language. I've talked with Sally Flocks, who represents PEDS, and she had some language. I didn't go exactly with her language, but there is some language I would insert to make it a little more jogger-friendly than the current, what we passed out this morning. Section 6 merely is the effective date, and the repeal is in Section 7. In the appropriate time, I discussed the amendment after if there's a motion to be passed.
Let me ask Mr. Spehaus if he would to come forward and maybe cross a couple of T's and dot a couple of I's with regard to
yes, sir. Specifically
the specific add-ins
yes, sir.
On top of the bill that are necessary and why.
If I could, Mr. Chairman, thank you. Section 1 and Section 3 were our add-ins. What we've done is we've taken the language in Section 3 and moved it back to Section 1. What we've done is we've moved language from driving with suspended license that was put in last year when the sentencing provisions for driving without a license were referenced to this code section. And we've taken that do not prosecute language and put it back in 40-5-20. Because practically what this did, and none of us caught it at the time, is it's actually barring prosecution for valid suspended license statutes or cases now. People are allowed to be arrested, be convicted, get their license suspended, get served notice of their license suspended, drive, get caught, and so long as they can put their case off long enough, we'll be barred from prosecuting them because they subsequently get their license back. So we're taking that out of 121 and putting it back in 20, which was exactly what the governor's office wanted. They don't want us, nobody wants to prosecute anybody that had a valid license. So that's all that does, Mr. Chairman.
Can you get into Can you give us a little more clarity on Section 2? Are you in a position to do that from your review?
I am. What I think that does, first of all, it references 40-6-77, which is over here in your Section 4 for you to be able to read. And it creates a suspension of license for a 2nd and 5 conviction of injuring somebody in the right-of-way. That was the...
And that's the essence of the Jackson bill.
That's the essence. That's what started it, is the Jackson bill. Yes,
all right,
sir.
so we're enhancing penalties for hitting somebody in the right-of-way a second time within a 5-year period.
Specifically, Section 2 creates a driving suspension for 30 days if you've done it 2 times and been convicted of it 2 times in 5 years.
All right, just want to make sure the committee's clear on that.
Now, you still get fined and feed, but you don't get suspended.
And in Section... Again, just to be clear, in Section 4, beginning on line 90,
that enhances punishment for a 2nd and 5. So the previous section we talked about dealt with a suspension. This just enhances punishment for a 2nd and 5.
Okay. On the hitting a pedestrian in the right-of-way.
Yes, sir.
Or a biker, correct?
And again, Section 5 has expanded the definition of pedestrian to make clear what it references.
Okay. Mr. Setzler.
Thank you, Mr. Chairman. I'm trying to track this. I was in the subcommittee the other day when Senator Jackson brought this the first time. I'm just trying to compare both then and now where we were coming from and what we're going to. My eye is certainly caught by the second offense, not less than 10 days imprisonment. I don't know where we're coming from on that. I guess the fines don't bother me as much, and what someone could be subject to. I'm certainly don't have opposition to someone being subject to up to 12 months, depending on the facts of the case, but a mandatory minimum of 10 days.
It's a 10-day sentence that could be suspended.
I'm sorry?
That could be probated or suspended.
Okay. Is there a practical effect of that other than, as the gentleman just said, is there, and where were we coming from? I mean, where are we today with respect to?
It sounds like you're being serious on the second offense. Practically, what does it mean? I mean, the cases are going to get evaluated on a case-by-case basis, and they're going to get sentences accordingly. This does not require that my recommendation or a judge's sentence that they have to go to jail for 10 days, period. The court's still going to have the authority to probate or suspend any of that. So.
Today, there's no jail at all for second offense. Is that right? No, it's a fine provision.
Right now, there's no jail, period, for first, second, third, fifth, or what have you. The only part of the code section is that fine up there. So it is a significant stiffening of the penalty as far as you've been convicted of it, now you've committed it again. So, and it's in a 5-year period.
And I'm not clear that the gentleman, when he brought the bill, had the 10 days, no more than 12 months.
I think it's in the first version I read of it.
For second offense? In the bill he brought. Thank you.
Ms. Benfield.
Yes, thank you. I've got a question about the definition of pedestrian. It's on page 4, section 5, lines 108 through 110. And it's basically any person afoot. And I was just checking the code, and the beginning of this whole title, I guess, 40-1-1, it says pedestrian means any person afoot. This is a little more expansive. My question is maybe better directed to Ms. Travis. One is, should we just reference, or should we be amending definition 40-1-1 to include this more expansive definition? And my second question is, what about persons in wheelchairs? Yeah. So you should, yeah, exactly. You should understand where I'm getting at on this one.
The 40-1-1 definition is throughout the code, throughout that chapter, throughout that whole Title 40.
Mm-hmm.
So you don't want to amend 40-1-1 because the issue is only with this code section.
Okay.
And the second one, with respect to folks in wheelchairs, is there? Trying to look at the serious injury by vehicle.
I just want to make sure we cover persons in wheelchairs.
Yeah, I think the wheelchairs are somewhere in there, but not in these code sections.
Mr. Chairman, I would not be in favor of forcing wheelchairs to a sidewalk, given the limitations of wheelchairs and the conditions of sidewalks in many areas. There are areas in which if you're forcing a wheelchair onto a sidewalk, you're as a dad who carries a child and pushes a child in a wheelchair, you would not. I would be in strong disagreement to put a wheelchair on the side forcing them to a sidewalk.
Oh, okay. I'm sorry, I misunderstood. I was thinking hitting somebody in a wheelchair who was in the right of way. I wanted to make sure that that was covered as a criminal offense, but not mandating that persons in wheelchairs have to be on the sidewalk. I agree with your point.
Yeah.
To your point, then, it would be a change to line 82.
Okay.
But that's on the fly. That's without knowing if there's other wheelchair provisions. Do you know?
I don't.
Okay.
I mean, I submit I'm certain that there's other laws to cover a vehicle leaving the roadway and striking somebody in a wheelchair.
Okay.
I'm with Representative Collins. I don't think we probably ought to try to force wheelchairs into this code section.
Ms. Abrams.
Mr. Spanos answered my questions about sections 1 and 3.
We're at 10 to 10. My sense of it is we have an original bill, and there are a couple of additional provisions that I don't necessarily see as being terribly controversial. I know that there are amendments. I think discretion being the better part of valor. Let's go ahead and digest this overnight. It'll be first up tomorrow morning, and then we can march on from there, just to make sure that the committee has a full understanding of exactly what the add-ons are on the bill, which, again, I personally don't see as being terribly controversial, but I do want to make sure that they're fully fleshed out for individual members. We'll go ahead and send out an agenda later on today for tomorrow, and we'll be adjourned. Thank you.